May I come in, sir? Thank you, sir. Yes, sir. Thank you, sir.
Your name Mandira Mahanto.
Yes, sir.
You expected to be judicial officers.
Yes, sir.
Suppose you became a judge.
Yes, sir.
Then first you will be magistrate, second class or first class, or what designation should be delivered to you?
So, I think that will be judicial magistrate second class.
Whether judicial magistrate second class is empowered to take cognizance of any offense.
Sir, generally no, but under the order of the Chief Judicial Magistrate, under section 190, he can take cognizance of the offence.
What do you mean by cognizance?
Sir, the word cognizance means when a judge applies his judicial mind so as to take proceed with a case against any person.
Okay, can you give that?
Yes, sir. Yes, sir.
Okay. You said that cognizance means applying the judicial mind particularly.
Yes, sir.
So it's under 190 of the CLPC.
Yes, sir. Sir, what?
Under which provision cognizance is taken?
Sir, under section 190 of CRPC.
190 of the
Yes,
CLPC.
sir.
Now, can the magistrate recall the cognizance order once he has passed it?
Sorry, sir.
Suppose you have taken cognizance.
Yes,
you are a
sir.
magistrate.
Yes, sir.
Then you have taken cognizance of the case.
Yes, sir.
Then on arrival, the other side, then he files an application that there are mistakes in the order,
Yes, sir.
or that you have no jurisdiction to pass any order or whatever.
Yes, sir.
You make out a ground that the order of your order
Yes, sir.
of cognizance
Yes, sir.
is to be recalled.
That is
Okay.
passing of cognizance.
Yes,
What
sir.
such is.
So can you yourself, the person who has passed the order of cognizance, can he himself or she himself recall it?
So,
Can I recall the order of cognizance?
so with the order of the Chief Judicial Magistrate.
Okay.
Usually order is recalled under what circumstances?
Sir, sorry, sir.
Suppose you are a magistrate committing some apparent error on the face of the record.
Yes, sir.
So when you can modify, review, or cancel your own order.
So that will be under review if there is any mistake on the apparent on the face of the record, then but not by himself, on the application of the applicant. Yes, sir.
Once you have stated that I applied my judicial mind and I took cognizance.
Yes, sir.
So can you say no, I have not applied my judicial mind? No.
That is not very simple. That suppose by mistake
Yes, sir.
I have taken cognizance
Yes, sir.
and an application has come, we make out that yes, I have done a blunder
Yes, sir.
by taking cognizance.
Yes, sir.
Can I recall it?
Yes, sir. On the application of the aggrieved party, and if there is sufficient grounds upon it, then yes, sir.
Okay, you verify this point because you may face this question.
Okay, sure, sir.
Because K. Matthew, there is a case,
Yes, sir.
and there are other things, whether a magistrate once takes a cognizance, whether he can recall.
Sure, sir. Thank you, sir.
The second thing, as you said that, can the court,
Yes, sir.
which has convicted an accused, and that accused files an application for review of the judgment,
Yes.
can the, as a magistrate, do it?
No, sir, not suo motu, only on the application of the aggrieved party.
Okay.
I think no, you can.
You cannot. You
Yes,
see,
sir.
the moment in a criminal case, a review is a creature of statute,
Yes, sir.
and it can only happen if the power provides under the statute.
Yes, sir.
And once you have passed the order,
Yes,
you
sir.
become functus officio,
Yes,
and
sir.
only whatever can be done by the higher courts.
Yes,
You have
sir.
committed a mistake, that's end of the matter as far as criminal case is concerned.
Yes, sir.
Then what is the situation in civil case?
In a civil-
Suppose this is the state of affair in a criminal case, you cannot set aside, modify your own judgment
Yes, sir.
or sentence.
Yes, sir.
So what is the situation in civil procedure court? Suppose you pass the judgment,
Yes, sir.
there is some material irregular. What are the provisions and under what circumstances, what can be done?
So that will be 100.
Don't worry, be comfortable.
Be comfortable.
We have come to teach you, to
Yes, sir.
advise you.
Yes, sir.
Huh?
Yes,
So suppose this question arise, the experts they may put in this question.
Yes, sir.
So that in
Sir,
CPC, what is the procedure laid down there?
for review, sir. Yes, sir.
You have got the judgment.
Yes, sir.
Then what are the avenues available, what are the law available to you to modify the judgment or a decree like that? Right?
So if there is any arithmetical or clerical mistake, then that can be done. Otherwise, amendment or any alteration to the judgment can only be made through review.
Clerical, mathematical error, 152, we can
Yes, sir.
see.
Yes, sir.
But the judgment, suppose some irregularity, suppose we have come to a wrong conclusion in the finding.
Yes, sir. Yes, sir.
Now you became apprised that I am aware of that fact. So
Yes,
that's
sir.
what is that. But
So that will be on the application of the aggrieved party. The grounds are first when there is no appeal lies, or if an appeal lies and when no appeal is preferred, or if there is any mistake apparent on face of the record, or if there is any new finding on the fact of the case which was not known to the party before filing of the said suit.
there is some, that the court of presiding officer of the court, suppose you could
Yes, sir.
not apprise that evidence which is already available in the record. Right? Then you can say, oh, this was not considered there.
Yes, sir. Yes.
So I came to know about this evidence and I am going to modify this, or I am giving it. Why you will alter your judgment?
Yes, sir.
151, nahi?
115 in civil side.
Civil side.
Yes, sir.
So you have the power to review, to modify your own judgment.
Yes, sir.
And section 151.
And order 47.
47 will work like that. Now, what are
Acha. Second thing, what is the difference between a review and a recall?
Review and recall. Sorry, sir. I can't remember right now.
You analyze the words, meaning, plain meaning you give. Recall, review.
Yes, sir. Can I try?
You, and you
Can I try then? If I so recall means when a magistrate or a judge call upon any judgment, then that would be recall. And review means when an application is made to the same court and to the same judge regarding to the same matter, that would be review.
Recall means to bring the fact, to bring the stage into the very same when he didn't pass the order. Okay, means totally recall.
Okay.
Recall the order and fresh
Even magistrate
review.
will-
You can take a different opinion, a different. Suppose you have taken a decision that this is correct, you can. But there must be error apparent on the face of record.
Yes.
There must be a case which miscarriage of justice.
Yes, sir.
That is, those are the two fundamental things. Which a review can be made.
Okay,
Even
sir.
the presiding officer himself, or
Yes, sir.
herself, can recall her own order if she finds it is wrong and erroneous. Nahi? So what is someone's case and what is warrant case?
So summon case are the case which are not warrant case. Means for which punishment will be less than 2 years, and warrant case are the case which are more of a grievous nature, for which the punishment is death, imprisonment for life, or more than 2 years.
Imprisonment more than 2 years.
Yes.
2 years and above.
Yes, sir.
So what is the difference in the trial? What do you say? What is the procedure for trying a warrant case?
Yes, sir.
What is the procedure for trying a summon case?
Yes, sir.
That's
So,
important.
yes, sir. Sir, in the warrant case, the formation of charge is required, whereas in the summon case, formation of the charge is not required. Summon case are of which is of a less grievous nature, and warrant case which are more of a grievous nature, and Yes, sir.
Suppose imprisonment 10 years and the death sentence is 300 too, so 12 years. So whether that will come within the purview of trial of warrant procedure case, or that will become provisions of sessions trial.
So that would be under sessions trial.
Sessions trial.
Yes, sir.
So defamation is of what type? You are law of crime and law of torts.
Yes, sir.
Okay. In tort, how many types of defamation is there?
Sir. Types?
Types of defamation. You know defamation on tort, na?
Yes, sir. Yes, sir.
Tort is a
Sir, tort is a civil, it is a branch of civil law. When a person's right is infringed, person's legal right is infringed, then he can move to the court and the court will provide compensation regarding it.
can for a defamation
Yes, sir.
a damage or a compensation can be given or not?
Yes, sir.
Suppose you
Compensation.
defame somebody.
Yes, sir.
So whether a compensation under the law of tort available or not available?
Yes, sir. Available.
So how many types of defamation is there?
The different kinds of defamation.
Kinds of
You want to say.
What is
Defamation
libel?
to reputation maybe.
Yes, sir. Yes,
What is
sir.
slander?
Yes, sir. Sorry, sir. I forgot. That would be slander and libel.
Okay. So
So
what is slander and what is libel?
So slander will be, it's more in a verbal form, and libel is more of in a permanent form.
visible.
Yes, sir.
Writing also.
Yes, sir.
So tort.
Yes, sir.
So whether it is a civil wrong or not,
Yes, sir. It is a branch of civil law.
civil wrong. So how do you differentiate civil wrong and a criminal wrong?
Yes,
So what
sir.
is the difference between that?
So main difference would be under civil law, the compensation is provided, whereas under criminal law, punishment is given to the offender. And here the deciding authority will be the civil court, and here will be the criminal court. And here the offender, the person who does the wrong is known as the wrongdoer in civil wrong, and in criminal wrong it is known as the offender.
So in civil wrong,
Yes.
that is the wrong is caused to a private individual.
Yes, sir. It is a private
But
individual.
in criminal law, that wrong against the society,
Yes,
against
sir.
law.
Yes, sir.
That is the punishment. When punishment is available, that is a criminal adjusted. But for civil, an individual.
Yes, sir.
Suppose dog of a person in the night barks too much, and old man's a neighbor is not sleeping peacefully in the night. Then what remedy is available to you? Under what law? I have a dog, it is barking in the night. Sir is staying in the next door neighbor, at this age he is unable to sleep.
Yes, sir.
His mental peace is going, being
Yes, sir.
damaged. So what remedy he has against me?
So the aggrieved party can file a suit for nuisance. Yes. If the aggrieved party's peace, comfort to his living is affected, then nuisance.
So first his mental peace, comfort is
Yes.
being at this stage or is being damaged,
Yes, sir.
definitely entitled to
Remove.
damage
Yes,
from
sir.
me.
Yes, sir.
Then how will provide me? No. That what is there? What relief or how being a judge you will deliver under what circumstance? Definitely every cause has a remedy.
Yes, sir.
He suffered from mental pain.
Yes, sir.
He definitely is entitled to get damage.
Yes, sir.
Suppose I will pay money and I will every day my dog will bark. No.
Yes, sir.
Then how I will be stopped from keeping the dog silent? What remedy is there under what law?
So injunction can be filed.
So I will be injected, I will be restrained,
Yes.
the wrongdoer must be restrained. So by way of injunction.
Yes.
What are the kinds of injunctions are available?
So temporary injunction, permanent injunction, and more will be mandatory injunction.
Permanent injunction you stated,
Yes, sir.
temporary measures is temporary injunction,
Yes, sir.
and that is prohibitory
Yes.
order of injunction.
Yes.
So it will be absolute and a permanent order will be passed.
Yes, sir.
So what are the ingredients? How is a judge will decide X is entitled for order of injunction? Initially temporary injunction, then that will be decided finally.
Yes.
So what elements are under law should be available
Yes, sir.
to get the order of injunction from you?
Yes, sir. So under case Dalpat Kumar versus Prahlad Singh, 3 criteria were given. The first one, the court is to see whether there is a prima facie case made out. The second one, the court is to find the balance of convenience, and the third will be whether the grant or the non-grant of it will cause irreparable injury.
So what is
Irreparable loss.
Yes, sir.
Irreparable loss.
Yes,
But
sir.
it can be compensated in terms of money or not.
Yes, sir.
So, little one question.
Yes, sir.
There is an agreement, TPAT is concerned. There is an agreement. X and Y entered into an agreement that X will pay 10 lakhs to Y, then he will register the sale deed
Yes, sir.
to Aarohan. There was stipulated time. Time is the essence of contract. That was stipulated. Within 6 months, he will pay the balance amount of 8 lakh. 10 lakh was the final consideration. 2 lakh advance. 8 lakh was to be paid.
Yes, sir.
But why did not pay? Whether he remember contract is there. That is agreement for sale.
Yes, sir.
Consideration to be paid 10 lakhs, only 2 lakhs advance paid. Rest 8 lakhs to be paid, and why to obtain the sale deed. There was no within 1 year to be paid. So how will grant injunction, or where you will not grant injunction? Why came that I had to pay, but X did not agree and did not come to rest office for execution of the sale deed? Whether Y is entitled to relief of injunction.
So, if he proves that he was always been ready and willing to pay the amount, then under the doctrine of part performance, and if he is already in possession of the property, then the court will allow him to not to dispossess him, but as it is a protective nature and not of an aggressive, it is only a sword, it is only a shield and not a sword. So the aggrieved party cannot injure him from giving the property to someone else. He can only protect his own possession.
You will see one thing. Already suit filed.
Yes, sir.
Any transfer during pendants of this suit, that is a lease pendants.
Yes, sir. Yes, yes, sir.
Which provision?
Lease pendants.
Your law of property?
Yes, sir. Yes. So 1 minute.
No, it's okay. Transfer of?
Property 52 number.
52. Yes, sir. 52. Yes, sir. Yes, sir. 52.
There is judicial mind to apply.
Yes, sir.
One thing, when the suit is pending, lease pendants transfer is equal not to transfer.
Yes.
No. Second thing, already contract is there, sale deed is not executed. Why can compel to execute the sale deed?
Yes, sir.
Since there was no execution of sale deed, no title passed.
Yes, sir.
So there is no charge on the property.
Yeah.
So when there is no title, can you say he has a prima facie case? If sale deed is not executed,
Yes, sir.
there is no title to him. Suppose possession would have been given, title it should have been given. Even if a sir did not give it,
Yeah.
then he can claim, protect his possession. No?
Yes, sir.
Okay.
Let's say suppose when you become if you are appointed and you are bestowed with the responsibility of a civil judge,
Yes, sir.
take it. I file a suit before you, with certain prayer, and delay, admittedly it's barred by law of limitation.
Yes, sir.
And filing a suit, admitting that it is barred by law of limitation. Also files an application, section 5, saying that you condone the delay and admit my suit.
Yes, sir.
What you will do? And what is the law?
So, if there is a sufficient reason for his delay, then under the doctrine of condolation of delay, he can be no, sorry. No suit, in suit, no, section 5 do not applies to suit, it only applies to appeal and application except for under order 21 of CPC.
Yes, now you have got it. So, what is further appeals? That the word is further appeals or applications.
Yes.
So, originally, the original delay cannot be controlled.
Yes, sir.
Okay, you are reading in KIT law school,
Yes, sir.
having science.
Yes, sir.
Okay, physics, chemistry, biology, okay, law of evidence,
Yes, sir.
IPC and CRPC.
So what is TI parent, can you say?
Yes, sir. Under section 9 of the Indian Evidence Act, TI parade is basically a parade conducted under the supervision of a magistrate in which the witness or any person acquainted with the fact and circumstances of the case is to identify the accused. Generally, the TI parade is done before the trial. As soon as the matter comes into the knowledge of the police officer, it is conducted. So
Who is to conduct the TI parade and what manner?
So TI parade is.
Object is to identify a culprit,
Yes, sir.
whether he has complicity with the commission of the crime or not.
Yes, sir.
You are a magistrate.
Yes, sir.
So who is to conduct that TI parade and how you will conduct that TI parade?
Yes,
What
sir.
is the manner?
So, first, on the request of the officer in charge of the police station, the magistrate shall conduct the TI parade, provided if the person who is to identify is mentally or physically disabled, then the magistrate has to see that he is perfectly comfortable in doing so, and it shall be videographed, and if required, the help of special interpreter can be taken.
One accused is
Yes, sir.
suspect,
Yes, sir.
suspected person. Then how you will identify? As a judge, and what procedure you will follow to identify him or her that she or he was present at the commission of the crime at the spot? What is the manner how to identify? Simple question. Yes, has come. You are a magistrate.
Yes, sir.
And now you are going to conduct a TI parade.
Yes, sir.
So in what manner that TI parade will
What happens, sir? What happens in the TI parade?
So, in TI parade, not only the person but also other persons are placed, so that the authenticity of the parade is to be known, whether he is identifying the person correctly or not. This thing is also done with non-living objects also.
What is the full form of TI?
Taste identification parade.
Suppose you are thin enough, we are fat. So how that identification can you conduct it? Hello.
Sorry.
You are thin, I am fat. So then he is also of similar stature. Then how will you identify? So if one thin person is there and we want fat person there, so easily you can be
Yes, sir.
identified.
Yes, sir.
So how that should be the duty of the magistrate?
So similar objects.
Similar complexion, height and
Yes, sir.
stature. No.
Yes, sir.
So that it should be easily identifiable.
Yes.
Then if one has correctly seen, he or she can easily identify.
Yes, sir.
And when you are identifying,
Yes,
you
sir.
also record that thing in the Otherwise, it will have a question in the High Court.
Yes, sir. Yes.
Whether he has given a
Whether it
certificate.
properly conducted or not.
Yes.
That manner is to be cross-examined,
Yes, sir.
which will give loopholes. So what is confession?
So confession is basically the admission of in terms the offense or all the facts which constitute the offense.
Under what section?
So it has not been defined under Indian Evidence Act, but
So what types of confessions are there?
so
Section 24,
so
judicial confession
Yes,
and
sir.
extrajudicial confession.
Yes, sir.
That define what is judicial confession and what is extrajudicial confession.
Yes, sir. So judicial confession is the confession which is recorded during the judicial proceeding, and extrajudicial confession is the proceeding which is not which does not come under the purview of the judicial proceeding. Confession.
Judicial proceeding is that confession before a magistrate which is a record under section 164 here.
Yes, sir.
Okay?
Yes, sir.
The extrajudicial confession means the confession is made other than the
Magistrate.
judgment court.
Yes, sir.
That is extrajudicial confession.
Yes, sir.
What is dying declaration?
Yes, sir. So dying declaration is the declaration which the person makes before his death as to the circumstances which resulted in his death.
मतलब 35 वाला नहीं 5 रुपये और साथ हो suppose one stated something
Yes, sir.
and he did not die,
Yes, sir.
then whether it will amount to dying declaration or not.
So that will not be amount as dying declaration, but it can be used to corroborate or to contradict him under section 145 or 157.
Suppose one has stated it while one is at the stage of on dying bed.
Yes, sir.
If that statement is made, verify that is law, I think that can be treated as a dying declaration.
Okay, sir. Sure, sir.
If one is on a deathbed, if says something that is to be presumed as a dying declaration.
Yes, sir.
And if he survives, then what is stated.
Yes, sir.
But if he deathbed से कोई थी, then it can be said.
Okay, sir.
So you were having personal law also.
Yes, sir.
So under the Hindu law and the Mohammedan law,
Yes, sir.
what is the law governing the marriage? Means who can have a marriage in Hindu law as well as in Muslim law?
Sir, sorry.
Unable to understand?
No, sir. Yes, sir. I was unable to understand the question.
There are two laws.
Yes, sir.
One is Hindu law, another is Mohammedan law.
Yes, sir.
Just tell me, first in Hindu law, who can marry? Whether a Mohammedan and a Hindu can marry, and it is valid under the law.
So under Hindu law, both the parties should be Hindu. If they are of different religion, then the marriage will come under the Specific Marriage Act.
Special marriage.
Special Marriage Act. Sorry, sir.
So in the Mohammedan law,
So Mohammedan law, a Muslim man can only marry, a Muslim woman can only marry a Muslim man, but a Muslim man under Shia law, he can only marry a Muslim girl, but under Sunni law, he can marry a Kitabiya or a fire worshipper.
okay. As far as Hindu law is concerned,
Yes, sir.
if there is a marriage
Yes, sir.
between a Hindu and a Muslim,
Yes, sir.
okay, and that marriage is registered under the Special Marriage Act because it is not recognized under Hindu law. What will be the property rights?
So the property right will come in Indian Succession Act. The succession of the
Whether
property.
there will be a severance? Check करना because these
Yes, sir.
things may be questioned because this is a question.
By virtue of a special marriage act, that girl acquired the status of a wife.
Yes, sir.
The question is whether she has the right to inherit the property or not. When the status exists as a wife, then what said that? Go for it.
Yes, sir.
Go through, huh?
Yes,
It's a
sure,
very
sir.
difficult question and the time emerges in this country because under the Special Marriage Act, your marriage only recognized because How many types of marriage acts in this country?
Types.
There is the Hindu marriage.
Yes, Hindu Marriage Act. Hindu Marriage Act, Parsi Marriage Act,
Christian marriage.
Christian Marriage Act, and Muslim, and there is
Muslim marriage.
Muslim.
Then?
Wow, thank you.
Yes, sir. Thank you,
Live
sir.
more and more. Like this, be comfortable.
Be comfortable and try to.
Yes. We'll be able to.
It's okay.
ଟିକେ ବେଶୀ ଷ୍ଟିପ୍ ହେଇଯାଉଛି କି ନା ହାତଟା
She is facing
ହାତ ମୁଭମେଣ୍ଟ ହେଉଥିବ ସ୍ଲୋଲି
Yes, sir.
मैंने केवल
and it gives the sign that you are comfortable.
Yes, sir. Yes, sir.
नहीं वेरी गुड से गोटे कथा होची से आमी सिना केवल तुमको लॉ भीतर रखि देलो
Yes, sir.
बट यू विल नॉट बी कन्फाइंड टू लॉ ओनली
Yes, sir. Yes,
you
sir.
also have to have some knowledge on culture tradition or international national affairs से 350 मार्क ना रहता है they normally center divide कुछ दी क्या करो बेस्ट ऑफ लक
The current affairs ପଡ଼ିଯିବ
Aଜ୍ଞା, sir.
ଯୋଉଦିନ ଇଣ୍ଟରଭ୍ୟୁ ହବ ସେଇଦିନ ସକାଳେ ଖବରକାଗଜଟା ବୋଲାକୁ ପଡ଼ିବ
Aଜ୍ଞା, sir.
ତାର ସେଇ 7 ଦିନ ଭିତରେ କ'ଣ ଇମ୍ପୋର୍ଟାଣ୍ଟ ହାପେନିଂ ହେଇଛି କ'ଣ ଏଗୁଡ଼ା ଡିଟେଲ
awards के कौन पाई चाहते हैं
Aଜ୍ଞା, sir.
Now, maximum receive selector, register.
Yes, sir.
ଏଗୁଡ଼ାକ ଟିକେ ମନେ ରଖ ଯେମିତି ମି ପ୍ରଫିଟ୍ ଗୋଟେ ମୁଁ କହିଥିଲି
Yes.
ସେ ଏଇ ଯେଉଁ ଟେକ୍ନିକାଲ ବାଲା ଟିମ୍ ଏଗୁଡ଼ାକ ସେଗୁଡ଼ାକ ସାଇନ୍ ଅନ୍ ଡେମନମ୍ ଇଞ୍ଜୁରି ଏଗୁଡ଼ାକ ଟିକେ ତାକୁ ଦେଖିକି ଯିବ କିନ୍ତୁ
Yes, sir.
ଜେନେରାଲି those posts are put to you
Yes, sir.
and you will explore I think.
second कथा होची when you are appearing before a board
Yes, sir.
the board knows that since you have scored well in the written examination so you have had some knowledge
Yes.
but they want to test whether you know it only theoretically or have some expansion of knowledge.
So procedural no. Theory already we have secured mark.
Yes,
So
sir.
but theory comes on.
Yes, sir.
But stress on procedural no. Like that time declaration, complaint,
Yes.
out of support trial of someone cases.
Yes, sir.
Any case filed by private complaint nahi.
Yes, sir.
200 what is issue like that. Procedural because that is to be judged because soon after joining you will be
Yes.
required to perform the duty
Yes.
with procedural law. Thank you. Wish you best of luck.
Thank you, sir.
Now,
Sir, can I ask a question?
Yes.
Can you give me advice on what or area should I improve?
what are the area?
Should I improve more?
So within this 30 minutes or something,
Yes, sir.
we cannot judge that what actually, but we wanted to know that all any interviewing body,
Yes, sir.
and we will try that whether you know it and you are telling or you are bluffing.
Yes, sir.
That is most important thing.
Yes, sir.
Saying no, that I do not know, also a good answer.
Yes, sir.
Instead of trying to bluff this way or that way.
Yes, sir.
Never bluff. Okay.
Yes, sir.
Straightly concede that, sir, presently, I don't know. Okay.
You stress on civil law.
Yes, sir.
Little bit.
Yes, sir.
You will answer all those questions what I go,
Yes, sir.
but little bit in civil.
Okay, sir. Sure, sir. Thank you, sir. Sir, namaskar.